So good morning, everyone. My name is Frank Robert Flasspohler. I am the attorney for EMS Legal Services, and we provide legal consultation to quite a few 911 districts around the state. I think about 31 at my last count. Although I talked to another one tomorrow, so maybe by the end of the day it'll be 32. But a great opportunity. I actually grew up in EMS, and so my first full-time job was as a 911 telecommunicator in Cooper County back, I think that was in 2002. So a little while ago, but I have a special place in my heart for the 911 community and really appreciate the opportunity to serve as legal counsel for so many great organizations throughout the state. Today, we're going to talk about telecommunicator liability, some of the special laws in Missouri. Many of those apply to all emergency services, but we're going to take a lot of time to look at Section 190.307, which is a very special statute that gives us some great liability protection in telecommunications for 911 centers. We'll look at a couple cases along the way and talk a lot about negligence and how that applies in the 911 setting. As we get started, let me see. Whoops. I guess I need to share my screen, huh? So where did my Zoom thing go? All right. So as I said, we're going to talk about liability protection for 911 telecommunicators. I want to just thank the Missouri State 911 Board, which has been kind enough to authorize this program for telecommunicator credit. Certainly, I appreciate their support and ability to do that so that we can give folks credit for attending today. Before we get started, I do want to mention a couple of special upcoming events that we have in the telecommunicator 911 community. 911 Goes to Washington, D.C. Will be February 22nd through 25th of this year. And so I know that we were fortunate and had some really great representatives from Missouri go last year. So certainly if you have that opportunity, I would encourage you to look into that. And then there's actually 911 Goes to Jeff City will be in April as well. So if you can't go all the way to Washington, D.C., at least come and join us in Jeff City. It's really a great opportunity to visit with our legislators who have significant influence on our industry, right? Because they can write laws that affect us a great deal. They can afford budgets and spending and influence things in that way. And so it is a wonderful opportunity for us as 911 professionals to go and interact with those who can make a great difference in our field. And so if you have the opportunity to do that, I would certainly encourage you to take advantage of that. I know Nina is the sponsor for the national one in February. And then
Supposed to call.
Okay. Do what?
Mike of Cedar County.
Okay.
Never got a link.
Okay. And then there is the one in Jefferson City is put on by the State 911 Directors Association. So watch for more information about those. They are really great events, and I would encourage everybody to participate in them. As we get started, I always like to introduce my family a little bit. So these are my kids, not my kids. I actually have them together with my wife, who I have a picture of here in a moment too. But these are our kiddos. They were at their Christmas concert on Sunday. And so if you ever see me at the conference, hopefully my kids are not far behind. Being a parent is really probably the most special thing in my life, next to my wife, of course. And so up here in the blue, starting up there on the left, that's Abigail. And then Eleanor is in the pink in the middle. Gracie has her Christmas sweatshirt on. Madison is down there in the bottom with her pink shoes. She's actually the only one who's not in school yet, but she was able to sneak in for the picture there. Henry is our preschooler there in the light blue in the middle, and then Frankie is our oldest. He is in sixth grade now, and they are certainly a lot of fun. I definitely enjoy being a parent. Of course, that would not be possible without my partner, Katie. Katie and I have been married for 14 years. And as you can see, we've been pretty busy during that time. Katie actually works now as an EMT for Howard County Ambulance. And so we all stay involved with emergency services, and I think she enjoys that a great deal. I always like to share a little personal suggestion. And so this past fall, we visited some of my friends in Omaha. And, as a parent, I have spent a lot of time cutting up French toast and pancakes and breakfast food. And we made pancakes over at my friend's house, and they have lots of kids as well. And so one of his daughters grabbed a pizza roller and she started using it to cut up pancakes. And let me just tell you, my mind was blown. It was like the most exciting intervention I have had in a while. And so I immediately went on Amazon and bought a little 2-inch pizza roller, and now we use that to cut up all of our breakfast. So if you are a parent or a grandparent or have little kids that visit you, that is my parenting hack share for the day. Go and get you a little pizza roller. Saves so much time in cutting up all that. And now the kids even like using the pizza roller, and they want to cut up their own things. So that's my special little parenting share for this morning. So let's move on then into the legal aspect of this presentation. I want to talk this morning about negligence. We're going to talk a lot about liability, what goes into when telecommunicators can be held liable or financially on the line for missteps or errors in their role as telecommunicators. And so I think it's good for us to start by understanding what goes into determining when liability, or in this case, negligence, exists. And so negligence occurs anytime there is a duty to someone, and we breach that duty in some way, and that breach results in injury or loss to that person. And so those are the three that I most often talk about, because typically causation is not too often an issue in the situations we're looking at in emergency services. But obviously there has to be some sort of connection between the breach and the injury that somebody suffered. And so in order for someone, a plaintiff, to go into the courtroom and prove that we are liable for an error that was committed, they have to prove those four things to the jury. So they have to prove that we as a telecommunications agency owed a duty to someone, and we'll see that that can sometimes be questionable about who we owe a duty to, because it's not sufficient to just say we owe a duty to the general public, for example. And so we have to have something a little bit more than that. There certainly has to be a breach of that duty, and frequently the breach and the injury are not as a big of questions, right? So we breach our protocols, we breach the regular standard of what we're supposed to be doing as telecommunicators. That's typically how they show that breach. Sometimes the injury is also pretty apparent. Somebody loses their life, somebody is injured, somebody's hurt by our failure to do something that we should have done. And then, of course, that causation. All of those have to be proved to the jury, and the jury has to be convinced, not beyond a reasonable doubt, but beyond a preponderance of evidence, which is like 51%, 51% more likely than not that each of those things are true. There are some different standards for negligence in the state of Missouri that I want to just kind of talk about as we go through, and so lay them out here to begin with. There is ordinary negligence, and so if all four of those things are present, ordinary negligence can be found to exist. And so ordinary negligence is just that really failure to use the normal duty of care that an ordinary person would use under the same situation. So in the context of telecommunications, ordinary negligence could exist if there's something as simple as a typographical error in an address or a misunderstanding of the caller's mumbled words. Um, Ordinary negligence, however, is not something that in Missouri we have to be worried about in telecommunications because of this statute we're going to look at here in just a moment, section 190.037 gives us protection within the telecommunications environment from any acts of ordinary negligence. And so we're not held to just that reasonable everyday standard. Gross negligence, however, is a much higher bar that the plaintiff would have to show. And Missouri courts have typically considered gross negligence as an action or a course of conduct which really shows this conscious indifference to a professional duty or to the safety of others. And so it's that reckless disregard, just a complete lack of concern for how what we're doing affects somebody else. It really is this mental state of recklessness. And so that's one of the things that then the plaintiff is going to have to show if they want to hold us liable for our breach of duty in that negligence situation. Really, where our telecommunicator would know or should have known that their conduct, that their failure to do something was going to create a really significant probability of harm, and they did it anyway. And so that's kind of what we look at for gross negligence. Willful wanton misconduct, we're also going to see in our statute. That's conduct that's really committed, again, with this intentional or just really extreme reckless disregard for the safety of others. It sometimes is approaching even the level of intentional harm. And so certainly we hope we don't ever see that in telecommunications, but it is an opportunity that we could be liable for our actions if we're really just so far beyond the scope of what we should be doing that we're really almost acting in an intentionally harmful way. In order for them to prove this, the plaintiff would have to show that the actor or the telecommunicator had actual knowledge of the danger and then consciously failed to avert it. And so, again, a pretty high bar for them to reach. There is what we'll see in the cases here in a minute when we talk about them, there's this distinction between a discretionary duty or a ministerial duty. And so a discretionary duty is one that we would define that we as professionals in telecommunications, and last year we were recognized as first responders under state law. And so certainly our state lobbyist, Mr. Scott Penman, has done a great job there working with the state 911 board to get that recognition for us on the state level. And that plays into many of the actions we do as telecommunicators require our professional judgment. And so they're not ministerial duties. They're not things we just do by routine or that are specifically mandated, but they are really professional discretionary decisions. There is some, when we talk about, and we'll talk a little bit about official immunity, that distinction between discretionary duties and ministerial duties is really important. So we'll look at that in a little bit more detail here in a little bit. But let's look at this section 190.307, really a wonderful statute for us in the 911 community because it gives us some really good liability protection, except in those cases of that wanton, willful misconduct or that gross negligence. And so I have highlighted in red where those exceptions are. That red is obviously not part of the original statute, but you can see here that we've got basically protection from any liability for any civil damages that result of an act or omission in the scope of being a 911 telecommunicator. And so when we're referencing those other sections, 190.300 to 190.340, those are specific to emergency telecommunications. And so There is actually a case where paramedics and EMTs attempted to say, well, we're also a public safety agency, and we're part of, the dispatch environment. And in that case, they had dropped a patient and they tried to claim liability under this, and the court limited that and really said, no, this Section 307 really applies to 911 telecommunications, and does not extend that liability protection to other emergency responders. But for us in 911, gives us some really good liability protection, ensuring that we're not going to be responsible unless the plaintiff can show that willful or wanton misconduct, or show those facts that arise to gross negligence. And so some really good protection there. Let's look at that maybe in a little bit more detail. So that kind of overview of 190.307, of course, is important because Missouri telecommunicators, this is really the primary way that we are protected from liability. It grants this what we might call qualified immunity, because it's not absolute, right? It doesn't apply if there's wanton or willful misconduct, or that gross negligence. But that qualified immunity that really protects us from liability for the acts or omissions that are performed in the connection with operating the 911 system. Again, it doesn't extend to other emergency services. This is specific for 911. Under the statutes, telecommunicators and their agencies can't be held liable in civil court for their failure to do something or their conduct in administering the 911 system, unless there's that gross negligence or willful or wanton misconduct. So again, the plaintiff has to get to that higher level in order to hold us liable for our actions. This protection applies over the life cycle of the 911 call. So from the moment that call comes in until its conclusion, but it also applies to the operation of the 911 center and anything that occurs in the scope of that operation. As I said, it's qualified. It's not absolute, because there are those opportunities to pierce through this liability protection. But this statutory immunity in 190.307 takes precedence over the common law official immunity for 911 telecommunicators. And so we'll talk about official immunity here in a minute, but this really kind of overrides everything else. It does work with other doctrines like sovereign immunity, which protects our agencies, and the public duty doctrine, which limits that liability for duties that are just owed to the public at large, like I mentioned a little bit ago, but really gives that extra layer of protection in 911. And so the interplay of all of these protections really means that lawsuits against 911 telecommunicators have some significant legal hurdles, unless there's really egregious misconduct on the part of the telecommunicator, which unfortunately we have seen from time to time around the country. But generally, this statute's going to give us some really good protection. Shortly after the statute was adopted, there was a pretty important Supreme Court case, Golden versus Crawford in 2005, where the Missouri Supreme Court had the opportunity to look at how 190.307 applied kind of in the context of all of these other immunities. And so in that situation, there was a caller who called 911, reported a man lying in the middle of the street near the intersection of Hill and Michigan. The telecommunicator, rather than using the computer mapping system, which they did have in 2025, of course we have much better ones now, but they did have a computer mapping system, but the telecommunicator chose to rely on their personal knowledge of the area and assumed that the location was west of the intersection, when in reality it was on the eastern side. And so the telecommunicator dispatched law enforcement to the incorrect location. The responding officer actually drove through the scene without seeing the man on the road. partly because the man was obscured by another car, but the law enforcement drives through the scene on the way to the address that the telecommunicator had given them, which of course was the incorrect location. The man lying in the road was subsequently run over and killed. And so his family brought a lawsuit claiming that verifying the address is a ministerial task, that there's no judgment involved in that, that it's just straightforward, something that everybody should do, and there's no discretion in how a telecommunicator verifies that address. Of course, the telecommunicator and the agency claimed official immunity, which applies to those discretionary decisions, and said, the official immunity protects us here. The telecommunicator was exercising their discretion in how they administered this call, and so they should be protected under official immunity. The Supreme Court, as they sometimes do, went kind of a completely different way and didn't look so much at official immunity, but applies this specific statute, 190-307, in a really solid way for the 911 community. Because what we might say was like a seismic shift in the way the Supreme Court is looking at our immunity in 911 by saying we're not going to look at official immunity for 911 agents. We're going to look at this special statute that protects them, because while official immunity looks at this distinction between discretionary and ministerial acts, there is no such distinction in 190-307. And so there's no need then for the court to get into an analysis of whether or not this was a discretionary or ministerial duty. In fact, the Supreme Court rejects that application completely in the telecommunications context. And the court holds that the legislature, by enacting 190-307, intended to create a comprehensive statutory immunity that superseded this official immunity doctrine for 911 telecommunicators. The court ruled that under that statute, it doesn't matter if the action was discretionary or ministerial. And really, the only relevant question then is whether the act was amounted to gross negligence or that willful or wanton misconduct. This was a very significant ruling because it really gives us a great defense in the telecommunications field. It effectively removes this ministerial loophole, takes that discussion about routine errors out of consideration, and so really then just focuses on whether or not gross negligence occurred and gets us away from that ministerial distinction. A similar case comes several years later in Henry County, and so I want to point out this when this case is taking place. Henry County is actually their 911 centers administered by a private company, and so I'm certainly not picking on any 911 districts or agencies that may be helping out in Henry County now. But in this Benton Court case, there was a 911 call came in about a screaming woman, or involving a screaming woman rather, and the call actually originated in Windsor, Missouri. But their computer system misidentified the address, and so partly due to the computer system, partly due to the error of the telecommunicator in verifying it, the call was associated with a duplicate address in Clinton, Missouri. Dispatchers sent the Clinton police officers, including Officer Christopher Ryan Morton, to the Clinton address. Unfortunately, the residents at the Clinton address were unaware of any issues, but they were also using methamphetamine, and so the officers came into the house. The telecommunicator had failed to notify the officers that it was a misdial that had originated from a different address, and so when they were in the house, then the officers were ambushed, and Officer Morton was actually killed by the residents of the house. Officer Morton's family sued, claiming that gross negligence by the dispatchers, which of course is the way that you can get around 190.307. and notably sued not only the telecommunicator in this case, but also the chairperson of the board of directors and the director were all named as parties. The plaintiff claimed that their failure to use the mapping technology really amounted to this gross negligence, that they failed to recognize the error, that they failed to warn the officers of the error, and that all of that amounted to gross negligence. This case actually resulted, it didn't go all the way through the court system, and so we don't have an appellate court decision or any case law on it, but it resulted in a pretty significant monetary settlement where the 911 Center's insurance company paid out. But I think it's important for us to understand that this gross negligence can be more than a single incident, right? So it can really be a systemic problem that includes a failure of training, a failure of policy, a failure to use the proper technology, rather than just the individual mistakes of a single telecommunicator. It also highlights, and we'll talk more about that, this duty to warn officers of potential dangers, because while we may not have while the public duty doctrine is going to protect us from liability for a duty that's owed to the general public, for our partners in the field, our field responders, we do have a special duty to them. And so we want to keep that in mind as well. So just kind of look at an overview here of the scope of this immunity protection of 190.307. Again, we want to remember it's not absolute. It's intended to focus on the 911 system and does not extend to those field responders. But it's specific because it specifically applies to receiving and handling and processing of those emergency telephone calls. It does not, however, extend to those occasions of willful or wanton misconduct or gross negligence. And so while it is going to protect us as telecommunicators, not going to protect our field responders, it does not reach out to cover them. Although we are all certainly operating within the same system, this 190.307 is really a unique protection for the 911 community. Let's look at some of the other more general immunities that do apply to everyone, just so we can kind of understand how they how our special immunity protection sits within this bigger field. Sovereign immunity is really the protection that protects government agencies from liability, essentially protecting them from being sued when we are engaging in governmental functions. And so sovereign immunity, of course, we have the word sovereign in there, and it comes to us from the common law, been part of Missouri as long as Missouri's been around. And so sovereign immunity is this idea that originally the king, of course, could not be sued unless the king gave permission to be sued. And in fact, we're a nice king here in Missouri. We do have a couple occasions where the legislature has said that we can be sued, and we'll talk about those in a minute. But generally, sovereign immunity protects government agencies when they're operating within government functions. It can be waived in certain circumstances, and so we need to be careful when we're purchasing liability insurance that there is a carefully worded provision in our agency's policy to ensure that we're not waiving that sovereign immunity unintentionally, because there have been another court case involving a 911 district that they had purchased a general liability policy, and the court essentially came back and said, well, this general liability policy does not have any notation in here that you're not waiving sovereign immunity, and so assume that there had been a waiver, where certainly I don't think that they intended that. So as administrators, we certainly want to be cognizant of that as we're getting our liability policies to make sure we've got that important waiver or protection against the waiver in there. As you can see here, there's a piece of the statute And I mentioned that sovereign immunity does not apply in all situations. There are two occasions specifically that the legislature have said that sovereign immunity is not going to apply. And one of those is in the negligent operation of motor vehicles. And so if, for instance, we had a telecommunicator who was driving a mobile command unit and that mobile command unit collided with somebody, we could be, or our agency could be liable getting around this sovereign immunity. Of course, we'd still have to look at those considerations under 190.307 and still have to show that gross negligence, but we'd be able to get around these protections from sovereign immunity, or the plaintiff would. There's also a waiver for dangerous conditions of public property. And so that waiver applies if the plaintiff can prove that there's a physical defect in our public agency's property that causes an injury. There have been plaintiffs who have attempted to argue that a malfunctioning 911 system or a glitch in the CAD software, which of course never happens, right? Because all of our CADs work perfectly, or a failure of radio infrastructure could create this dangerous condition of property. But the courts, fortunately, have been pretty consistent in interpreting it to mean physical defects in real property. And so there has not been this extension to, like some have argued. And so a glitch in our CAD system or a bad radio does not rise to that dangerous condition of physical property that gets us around or would get a plaintiff around sovereign immunity. But, if we have a tower somewhere and that tower is in danger of collapse or not properly maintained, and it collapses and causes damage, that may be an occasion that we need to be worried about whether or not sovereign immunity would protect us there. Official immunity is something that's frequently relied upon by our field responding partners because where sovereign immunity protects the entity, official immunity really protects the individual public employee. It is a judicially created doctrine, and so it's not something that necessarily was part of the common law, but it shields public officials from liability for their alleged acts of negligence that are committed during their exercise of their official duties and in the performance of discretionary acts. And so when we look at official immunity, that distinction between discretionary and ministerial acts is a very, very important. And so for our field responders, they need to understand the difference between a discretionary act and a ministerial act. And so a discretionary act are really those acts that require the exercise of our professional reason and judgment in determining how we should do something or whether or not something should be done. And so frequently we might think about a police officer's decision to initiate a high-speed chase or a fire commander's strategy at the scene of a fire call, or an EMS paramedic's decision to administer a certain drug based upon their protocol. Those can all be discretionary acts that they're using their professional judgment to decide one way or another. And those discretionary acts are typically protected by official immunity. What is not protected by official immunity are ministerial acts. And so ministerial acts are usually those clerical duties that are just performed almost in a routine manner. There's no option, there's no choice or discretion in the way our field responders perform them. And so there's simply a legal mandate or order to perform them in a specific way. And so, for instance, in EMS, we can sometimes see some liability for failure to properly document because failure to properly document is not one of those discretionary acts, right? And so we need to certainly document our trip tickets very carefully. It can also include failing to fill out a specific form or follow a mandatory step-by-step checklist. All of those things are not protected by official immunity. Again, the good news for us in the 911 community is that Section 190.307 essentially for us supersedes these this protection of official immunity. And so while in the Golden case, the plaintiffs were really heavy on arguing that this call taking was a ministerial function. And they talked about telecommunicators, of course, following rigid scripts like emergency medical dispatch protocols, and that therefore there was no independent judgment. And so that should just all be considered ministerial, and that would strip telecommunicators of their official immunity. But the decision in Golden essentially just sidesteps that, ignores that completely, and points to Section 19307, and really establishes that gross negligence as the standard for all acts that are related to the 911 operation in order to get to liability. Even if that act is ministerial, even if it maybe would be considered ministerial in a different situation, that specific statute's going to give our telecommunicators protection from ordinary negligence under that statute. But it's important for us to remember official immunity in the event that there would be things that maybe could, within 911, fall outside of the protections of that operating a 911 center. So different administrative duties may fall outside of that. And so there are occasions where it would be important, but generally for us as telecommunicators, that 19307 is going to give us the liability protection that we're looking for. Our third and kind of a key doctrine of liability protection is this public duty doctrine. It is a common law principle, again, that states that the public employee's duty is owed to the general public and not necessarily to a specific individual. And so it makes it really hard then for any specific individual to allege a breach of that duty. Because unless you have a duty that's owed specifically to you, that general duty is not sufficient to prove negligence. Which kind of comes out to, a duty to everybody is a duty to nobody, because there's no liability that we incur when it's something that we owe as a duty to the public at large. The courts have really justified this doctrine in order to protect our public resources, because if every citizen, of course, could sue for a delay in police response, that would probably break our local governments. We'd have almost infinite liability if every time we did something wrong to the general public, we could be held liable for that. And so that's essentially the consideration that the courts have looked at. Let's look then just at some of these areas where gross negligence can come into play in the 911 center. And so there are different opportunities. We want to make sure that we are training people correctly, adhering to our operating procedures, because there may be the claim that failure to do that is going to result in gross negligence. And so Section 650.340 provides some training requirements for our telecommunicators. Of course, I'm sure we're all familiar with that. Police, fire, telecommunicators have to have 16 hours of initial training, and then there's an additional 40 hours for emergency medical dispatch training, all really important training requirements. And so if we have telecommunicators that are routinely operating in our 911 systems that are not trained in compliance with that statute, we'd maybe be pretty concerned that there is some gross negligence on the part of our agency by failing to provide and ensure that mandated training is in place. Especially, of course, if one of our untrained telecommunicators makes a pretty critical error. Of course, a plaintiff then is going to argue that placing that untrained telecommunicator on the console may amount to deliberate indifference to the safety of the public, because we're not meeting the training requirements that are put out there by state law. And so we certainly want to make sure that those are in place. We want to make sure that we retain pretty clear records about our training and how we've ensured that our telecommunicators have met those training requirements. Because if we don't have records, then almost certainly a jury is going to conclude that the training was not provided. those training requirements are really important because again, they show that we're complying and we're not being grossly negligent. Our own operating procedures can also be something that can be used as somewhat of a yardstick to measure gross negligence by. And so we want to make sure that our operating procedures, that our folks are well trained on those, that they are following those carefully, and that when appropriate, our operating procedures allow for discretion. Because if our operating procedures are too rigid, too specific, and there's a variance from those operating procedures, then we may see more of an argument that that variance amounts to gross negligence. Typically, that rigid application is just something we want to avoid. So if, for instance, our operating procedure says our telecommunicator shall verify the address 3 times, and then our telecommunicator only verifies it once, the plaintiff's attorney might allege that that's a willful or wanton violation of the policy. And so we want to be careful that we've drafted our policies that are realistic in the way we're operating in the 911 field, and that allow for that operator discretion when it's appropriate. And so, rather than using phrases like shall always do this, we might want to review those policies and make sure it says that our telecommunicators should generally verify the address 3 times. Keeping in mind, there may be occasions where we don't necessarily need to verify the address. So or at least not verify it 3 times. So you have a call at the county courthouse, we probably don't have to ask them to say the address 3 times over, right? Because we've should generally verify the address may be more sufficient and appropriate in that situation. Of course, there are certainly steps that are truly mandatory for safety that we want to make sure everybody's following every single time. And if that's the case, then the policy should say that. We talked with the public duty doctrine about how it does not generally protect from liability, or it generally does protect, I'm sorry, from liability to the public. But we have a different duty toward our field first responders. And so as first responders in 911, certainly we have a special relationship with our field responders. As telecommunicators, we have a professional duty to relay all known safety information, all relevant information to our responding officers, to our responding paramedics and EMTs, our responding fire personnel, that all of the information that we're getting that could be important to them, especially relating to things like safety risks, we are passing on to them. And so if our telecommunicator is aware of a specific danger, like the caller says he has a gun, or we have a history of officers being assaulted at this address, or the suspect may be suicidal, they have to relay that information on to our field responders. And the failure to do so may create a danger that then is going to come back and be that gross negligence, that wanton willful misconduct that's going to get around the liability protection of 19307 in the event that our field responders are injured or killed, and that they or their family then are suing for liability. In the mental health context, Missouri law does also impose a duty to warn on mental health professionals regarding patients who have a serious threat of violence. And our telecommunicators often act as a conduit for this information. And so if a mental health professional calls 911 to warn of a dangerous patient, then we have a duty and responsibility to make sure that that warning is passed on to the responding officer. It doesn't have to be over the radio. Maybe we do it by phone, but we certainly do it and we document that we've done it. Because otherwise, both our telecommunicator and our agency could face some pretty significant liability exposure if our field responder is injured because they did not have that information. So just to kind of recap, I want to look back over all of these immunities that we've talked about. Of course, our key one right here at the top is our 190.307 statutory immunity that applies to our 911 agencies and all of our telecommunicators. And it relates to all actions that are included within operating the 911 system. And the only way to get around that is to have the presence of gross negligence or wanton willful misconduct. And so we certainly want to be cognizant of that. Sovereign immunity does also protect our 911 agencies, but it also protects all public entities. So from municipalities to counties, school districts, also our emergency partners, our fire and EMS and law enforcement in the field. It is a common law principle. It's codified in 537-600. And it does include a couple exceptions there. So we can still be sued for motor vehicle accidents, and we can still be sued for dangerous property conditions. Official immunity, which generally is not important to us in 911 because of that protection of 190.307, but also a common law principle that protects individual employees. So in the same way, sovereign immunity is going to protect the agency, official immunity kind of trickles down to protect those individual employees for their discretionary acts. It does not cover those ministerial acts, those things that they have to do simply by routine. And of course, it also doesn't, there is a gross negligence and malice or bad faith acts that are also accepted from or official immunity. But as I said, in the 911 context, it's really superseded by our protections in 190.307. However, we do have the benefit of that public duty doctrine that is applying to us in 911. And so that duty to everybody is really a duty to nobody. And so except for our field responders, where we have that special relationship, where we have that special duty to them to make sure that we're passing all that information, those important details along to them. Just to show you some of the, and this is from the Missouri Department of Public Safety from 2019 to 2021, the different liability claims that have been filed. And so just kind of the number that we see, certainly the most prevalent one are those just failure to provide adequate dispatch, right? Negligent training does come up in there. That failure to relay critical information. We see some claims of that as well. And then violating the standard operating procedures and the breach of that public duty doctrine, just to give us kind of an idea of some of the claims that arise in this area. One last case I want to look at in 2014, Jessica Thompson had actually called 911 because she was concerned about her boyfriend that was abusive. Unfortunately, the telecommunicators sent the officers to the wrong district or to the wrong address. I'm sorry. And the address they actually sent them to was a non-existent address. And so a pretty simple review of the computer mapping system would have indicated that that address could not have been correct because the address that they provided to law enforcement did not exist. Of course, law enforcement goes to the wrong address, and in the interim, while it takes about half an hour, they're looking for the correct address. And while that happens, Jessica Thompson is actually fatally shot by her boyfriend. There's a groundskeeper who's also murdered by the boyfriend at the same time. And so the 911 audio in that situation was alleged to have been pretty awful. The dispatcher really kind of came across, according to the plaintiff's attorney, as kind of a disinterested, unconcerned fashion, very cavalier on the telephone, and so almost this attitude of indifference to the caller. I point this out because I also do a course for EMS liability, and we've seen several criminal cases involving field responders, not just EMS, of course, law enforcement as well. And really, when there's the presence of indifference, oftentimes we see courts that are more willing to get around or look beyond some of the liability protections we would otherwise have, whether it's sovereign immunity, official immunity, or perhaps even the protections of 193.07. When there's this presence of indifference by our first responders, I think whether it's field responders or us in telecommunications, we have to be very careful because the courts are less likely to apply that liability protection when it seems like we aren't even concerned with doing a good job. And so I point that case out because of the similarity there to some of our other field responder cases with that attitude of indifference. The St. Louis actually settled this case for $500,000. $500,000 is what they paid out in a settlement here to Miss Thompson's family as a result of that. So some pretty expensive disinterest on the part of the telecommunicator there. So let's look at some of the best practices for us in telecommunications as we kind of wrap up here. And so we certainly want to establish robust standard operating procedures that that clearly define our telecommunicators' roles and responsibilities, but also allow them the freedom to exercise their discretion when it's appropriate. And so we don't want those standard operating procedures to be more specific than we need them to be, because we don't want to create the opportunity to allege gross negligence because we failed to follow a shall in the policy when really it could have been a should do something. We certainly want to ensure all of our 911 telecommunicators receive the state mandated training, that they receive that continuing education, and that we maintain documentation of that training and their proficiency in their role. We should have in place regular call monitoring and review processes so that we can identify areas for improvements and best practices, and that we can also identify any possible deficiencies in the performance of our telecommunicators function and maybe provide additional training if it's appropriate. We certainly want to have clear protocols about relaying all safety information to our field responders. So certainly to our law enforcement, our fire partners, our paramedics and EMTs in the field, especially regarding those mental health threats or other high-risk situations. We want to make sure that information is being communicated to them. We do want to make sure our folks have comprehensive training on the proper use of our technology, including call verification tools, including those mapping features, so that they really can do the best job that they can and use all of those resources to help us out in getting that information out into the field. We want to foster strong partnerships with our local law enforcement agencies, our fire departments, our EMS agencies, and always be in dialogue with them about how we can continue to improve our community-wide approach to public safety. And then, we want to make sure we've reviewed our insurance coverage, keep those careful records to stay informed about legal updates, make sure we've got good record keeping and mitigate any potential liability as it arises. Just some wellness resources here I want to point out. So we certainly, to the best that we can, we want to offer these counseling and support sessions, confidential counseling sessions and debriefing, especially after bad calls, are really important. A lot of times, and that's not just us in 911, but we have kind of the tough it out attitude. We certainly want to get beyond that and provide those opportunities for counseling and debriefing after those traumatic calls. Warriors Rest Foundation is actually sponsored by the Department of Public Safety, and it provides some really great peer support training, and it's free. They host those throughout the state, do some day-long, or I think there's even a couple day-long peer support training. There is CIT training, all really great resources to recognize the mental health implications that we certainly want to have for our field responders, but for our telecommunicators as well, and those are great opportunities for us to be in the same classroom, talking about the same issues. And so not only do we, by participating in that, bring that back to benefit our own telecommunication center, but we can help educate our field responders on the mental health stress, and the anxiety that goes into often never seeing the resolution of those calls that we deal with in 911. And so certainly we want to participate in the greatest way possible. I'd also encourage you to look into any policies you can have in place that just include kind of this ritual recognition for telecommunicators that are engaged in hard calls. And so I go to a lot of 911 centers, and they've got boards with plaques or recognition pictures anytime we do telecommunicator CPR, anytime we help deliver a baby in the field. Any of those occasions are really just great triggering events for us to recognize our telecommunicators. And so we can recognize them with a simple challenge coin, with a little plaque. We can certainly recognize them on our Facebook page, promote the really good, the good work that they're doing. And so just consider having a policy in place that has some of those triggering events. So you don't have to think about it. It's just every time you get one of those calls, here's how we're going to recognize those people. So just kind of some of our concluding thoughts. As I've said, Missouri has this really great statute for 911 telecommunications, 19307. Provides some really broad statutory immunity from civil liability for actions within our 911 duties that shields us from lawsuits, except in those cases, of course, of willful or wanton misconduct. It's wonderful that statutory protection exceeds the common law official immunity that our field responders deal with. But also that it plays in with sovereign immunity and that public duty doctrine. And so really gives us some great protection in 911. Of course, we certainly want to do a great job. We don't ever want to be willful or wanton, but we can do a great job knowing that the law is very favorable in its protection for 911. And so that's it. That brings me to the end of the presentation. I do have my email is here. If you ever have any questions, you're welcome to email me. That's also my cell phone. Anybody is welcome to give me a call on my cell phone, although I will say that with the caveat that please keep in mind that generally I represent agencies, and so most of my clients are 911 centers or ambulance districts. And so if you're an employee of one of those places and you're tempted to call me because you've done something wrong and you think your employer is going to fire you, just keep in mind I may well be your employer's attorney. And so calling and confessing a bunch of stuff to me is not the way to go. But if there are general questions, I'm certainly happy to do what I can to help you out. So I am going to end the recording here, and then we'll see if there are any questions. I do have one Q&A here. The special relationship between the dispatch and the caller. So that is a great point. Brad England from Crawford County asked to talk a little bit about the special relationship between the dispatch and the caller. There are, in general, we don't have a special relationship with our caller unless we do something that maybe puts us outside of what we would normally just be doing in our telecommunications dispatch role. And so if, for instance, we start giving the caller instructions or certain assurances, and so if we tell a caller who's involved in a domestic violence situation, perhaps to go and lock yourself in the bathroom or stay there, you'll be safe, help is on the way, things like that can start to create a special relationship between us and the caller. And so generally, if somebody calls in 911, my dad's having chest pain, no obligation to the caller there. But if we start giving instructions, we start telling the caller how to act in certain ways, then we can potentially create a special relationship there. So yeah, thank you, Brad, for that question. I appreciate the opportunity to clarify that. Does anybody else have any questions? If you do, raise your hand and I can unmute you. Otherwise, I'm going to stop the recording.